Nthabiseng, good morning. Thanks as always for being available to us. Just share with us your insights into what you heard unfold in court. There is a parallel process happening as well insofar as the extradition request is unfolding. So share with us from your perspective what stood out for you in court proceedings in Durban this morning.
Well, today is the first appearance, so basically just covering the basics in terms of what the accused persons can officially be charged with regard to this matter, and then the defense attorneys obviously now stating their case on basically the merits of the bail application, if there's going to be one like they said it's going to be there, and then confirming the accused addresses, etc., etc. So now, while this is happening this side, in eSwatini, we are still dealing with the extradition part, wherein the eSwatini courts want to deal with the extradition, but also their own criminal charges, wherein the accused persons that side, where they're illegally, and then they want to follow through with that process. The hope is that we will not have to wait that long for the extradition process to happen, such that the accused persons that are in eSwatini can now be added as accused persons this side of the world, and then the matter can proceed. So come, is it the 6th of March? Yes, come 6th of March. Yeah, at that time, bail application will be dealt with. But from what we heard in the media briefing that was done, we know that the accused persons have previous convictions of the similar kind, and also some of them have pending matters of the similar kind. So it's going to be a Schedule 6 bail application, and the likelihood of the defense attorneys to prove what exceptional circumstance is going to be a little bit steep, but we'll see how that one will work out.
All right, we're just sharing with our viewers now what that charge sheet is looking like and some of the timelining around when the arrests were made. I think it's very important in cases like these, and Nthabiseng, it also offers a really unique opportunity for an education of sorts for our viewers and for all of us as to how court actually functions. I want you to go back to the bail verification process, and the magistrate there was sharing a couple of dates in terms of when some of the postponements might be made to allow certain processes to unfold. Just walk us through the bail verification process and the requirements therein.
So in terms of Section 57, 58, and 59, the state is allowed to not grant bail on the first appearance. It is also covered within Section 35 of the Constitution, only for it to be on an interest of justice basis, in that they need to ensure that, one, they have the SAP 69s of the accused person, so the SAP 69s are the previous conviction, and then two, they need to ensure that the addresses that the accused persons have granted are verified. So in other words, if accused 1 to 7 say they reside in Ferndale somewhere, then they need to go to that place and verify that address. The people that reside there must confirm that the accused do reside there or can reside there should they be granted bail. And then thereafter, they need to go speak to the victims, the families, to understand what the implications thereof should bail be granted, and then the court will now look at all that information along with the affidavit that's going to be made by the IO, the investigating officer, which the state relies upon in order to get the prima facie evidence at this stage, because remember, right now, bail is on a balance of probabilities. It's not a beyond reasonable doubt kind of situation. So that is what the state now needs to go and verify. And then on the accused side, what we need to do as defense attorneys is to ensure that we know each and every single previous conviction of our clients and any pending matters or any warrants of arrest that could possibly be out. And then if there is more than one address, we need to ensure that come the date of bail, we have the people that are going to accommodate the accused persons in court to confirm that if address A that we gave to you was not verified in that the person residing there is saying the accused can't stay there, here is a person B who will then confirm. So stuff like that.
Right.
Sorry. So, yeah, that's what the Schedule 6 bail application will look like.
All right, so I want to come to one of the contentions that were made and raised by Advocate Paul Jorgensen, who is representing two of the accused around the request for them to unmask themselves. You heard, I don't know if you were watching the crossing and the interview with Tony Forbes a little bit earlier on. It was saying, you know, we should be able to see who these people are. They've got full hoodies, full face masks, so we can't see them. And then Magistrate Vincent Tlaswayo then ordering the removal of those face coverings. What the defense attorney put to the court was, it's possible that they might be wanted in other cases, and so it could contaminate the suspect identification process. What are your thoughts on how that was managed in court, and whether there was any legitimacy to the advocate making, you know, such a caution?
That doesn't make sense to me. We have dealt with so many cases, or let me speak for myself. I have dealt with so many cases wherein the accused person has a warrant of arrest already out for them in a different matter because they couldn't get caught at a scene. And then when they get arrested in the matter that I am handling, the SAPS has a system wherein they alert one police station to confirm that this person that you're looking for by way of fingerprints when they get arrested is now detained in prison X. And then they know when the first appearance of this person is going to be. They're going to come there anyway, and then they're going to arrest that person after their first appearance and take them to another matter for first appearance. So it really has no relevance when, in my opinion, at least, and in my experience, wherein the accused person, when they unmask themselves, is going to prejudice any identity parade or whatever, because if the witnesses on the other matters know who they are, even if they were to put them amongst other people, they don't need to see this person on TV. They can point them out anywhere else. So that doesn't make sense to me.
Nthabiseng Dubazana, thank you very much for talking to us this morning and sharing your analysis on how the legal process unfolded in court today.